We are often asked questions about family violence safety notices. So what I'd like to do is just go through 10 points about them. It doesn't cover the whole topic, but to give you some idea. The first point is that a family violence safety notice is one that is issued by the police. So a person who is of a rank of sergeant or higher can issue a family violence safety notice. Secondly, the issuing of a family violence safety notice is where there's a belief that there's an immediate risk to someone. And the third thing I'd say about them is that they always have conditions attached to them. Those conditions can vary. Oftentimes they seem quite absurd to all the parties involved, but they can range from not being allowed to contact somebody, not being allowed to approach them, not being able to go near a particular residence that somebody is living at. But sometimes they're more limited and people can still live together, but they're not allowed to commit acts of family violence. Depends a lot on the police involved at that stage and making that interim order and how they are viewing the situation. When it gets to court and a magistrate is appraised of the full situation, they don't have to go along with those conditions. And the fourth thing I'd say is that it has to be served on the respondent. So what I mean by that is that the person who's been given the interim order not to commit family violence and to attend court in a date in the near future, that's the respondent. They have to be given a copy of the order. You obviously can't breach an order that you don't know exists. So it's important that if the police are saying, look, you've got to come and get the notice off us, it's important you ring a lawyer, but also that you go and talk to the police and get the order, because that saves you the hassle of them coming around to your house with a squad car or going to your work and serving up on you there, which is often unnecessarily embarrassing for people. And the fifth point, which flows on from that, is those notices are automatically a court application. They are a temporary order saying don't commit family violence of the type that we're saying, and then you must come to court. Normally within about 5 days' time you'll be listed at the local magistrates court. You don't want to wait till the last minute. As soon as you get a notice, go and see lawyers, start working out how you're going to deal with it. If you wait until the day, you're not going to have worked anything through, and almost inevitably the court will adjourn for some period, be it a number of weeks or months. And so you do yourself a real disservice if you don't get onto it straight away. And what flows is the sixth point, that the police monitor compliance. So if you breach the order by contacting the person who you've been told not to, they will charge you for breaching the order, and also it means your chance of actually having the order rolled back is less, because the court will say, well, you didn't obey this order, so why should we agree that the order isn't necessary at all? So it's really important, comply with your order. Don't make a poor situation worse. Even if you really want to talk to somebody, now is not the time to do that. If you have an order saying that you shouldn't, just follow the process, or you're even less likely to have contact with a person in the long term. And the next point I'd make is that children can be included in orders. You shouldn't take from that the children have any involvement in that decision, because it's not in their control. This is made by the police, and even if the issue is between a person and their partner, generally the kids are put on the order as well. It's something that you just need to go to court, be prepared, and then you try and have the order varied at that point. And there is inconvenience in all of this, but you have to do the process correctly to get the outcome that you want. The next point that I'd make is that the order is effective until the court hearing. So as I was saying about follow the process, your order will be in place, you get to court, and the court will then either extend the order or knock it out or adjourn it off for a directions hearing. It just stays in place, and unfortunately there's such a delay in the court system with these orders that often you're just trying to vary the conditions so that you can get something that people can live with until the hearing of the matter, rather than getting it knocked out on that first occasion, because the court often just don't have the time or the capacity to deal with things. So you're in for the long haul. Just go and learn all about these orders so that you can feel comfortable that you know what's going on. And the way you do that is you sit and talk to a lawyer who deals in these sort of cases all the time. The final point is that these are orders that come under the Family Violence Protection Act, and so it's always worth acquainting yourself with what is impacting on you. So you can just go online, you can find an act, you can look at the section, you can think about it, you can think about the conditions, write down notes, because when you go to see your lawyer, you want to say, well, what's going to happen about sport on the weekend, or how am I going to be able to access my passport? No, you just make a list, and your lawyer should be able to answer all your questions. And frankly, if your lawyer can't answer your questions, then get a new lawyer.